ಮೈಕ್
ಅಲ್ಲ ಈಗ ಮಾತಾಡೋದು
ಮಂಜೆ ಮೈಕ್ ಅಲ್ಲಿ ಮೈಕ್ ಇದೆ ತೋಳ ಹ್ಯಾಂಡ್ ಮೈಕ್ ಇದೆ
ಕಾಲರ್ ಬಂದು
ಕಾಲರ ಏನು ಈಗ ಸ್ಟಾರ್ಟ್ ಅಂದರೆ ಹೆಂಗಿರುತ್ತೆ
ಏನು ಮಾಡ್ತಾರೆ
ಇಲ್ಲಿ ಮಾಡ್ತೀನಿ ಇದು ಸ್ಟಾರ್ಟ್ ಇದೆ ಇದು ಶುರು ಮಾಡಲ Good afternoon, friends. This is the third lecture in the series on the medico-legal issues. And today we are discussing a landmark judgment on the consent delivered by Honorable Supreme Court in 2008. And since then, entire country is following. All the courts, consumer court, criminal and civil courts are following this judgment. What is the consent in medical practice? The case title is Samira Kohli versus Dr. Prabha Manachanda. I think this judgment was circulated in the group, and I presume you have gone through at least gist of that judgment or at least few contents of that judgment about the consent. In general term, consent, they say, for any purpose or any agreement or anything, you need consent. What is the Samira Kohli versus Dr. Prabha Manachanda? Very landmark and very typical, and the consent evolved from this judgment, what we say. Since then, we are following the Bolam's test, the reasonable standard of practice. Throughout world, it was this case was Bolam's test. Till today, Bolam's is followed in the Indian courts also. Now we will turn to this case now. Samira Kohli was the patient. She was an unmarried lady, about 44 years, visited the clinic of Dr. Prabha Manachanda. In the legal terms, it is known as she is a respondent. Respondent means opposite party. And Samira is the complainant because she knocked the door of Honorable Supreme Court. She is designated as appellant. So I have omitted those words to avoid the confusion amongst us. So Samira was the patient, unmarried, 44 years, approached Dr. Prabha Manachanda for her irregular cycles and heavy bleeding for 8 to 9 days. And doctor examined, it was in the May 1995, I think almost 40 years back. The doctor examined her and ultrasound was advised. After examination, after the report, she called the patient, you need some further tests to confirm the diagnosis. She was suspecting because she felt some mass and fibroid, and let us confirm by further test, invasive test. It is a laparoscopy under general anesthesia. Come tomorrow. Accordingly, Samira came on next day and in the clinic, that is the daycare clinic also, and she was admitted. So you know, at the time of admission in any hospital or any care center, they take forms. On admission, patient signatures were obtained on the admission and discharge card, the consent form for hospital admission. You all are aware, when the patient gets admitted, that time the hospital will take, I am ready to get admitted and so the test, I am ready to undergo any test from the hospital. So consent form for the hospital admission and medical treatment was taken. Then the consent form for surgery was also signed by the complainant, means patient. The patient was taken into the operation theatre, laparoscopic procedure started. But in the meantime, they noticed some findings, and the assisting surgeon, Dr. Lata, she came out from the OT and took the consent of patient's mother. See the sequence here, it is very important to understand the concept of consent. She took the consent of patient's mother, who was waiting outside, for performing hysterectomy. Lata might have told, your daughter needs this surgery, hysterectomy. So she took the consent for hysterectomy. In the good faith, her mother signed the paper, consent form, and Dr. Prabha performed abdominal hysterectomy, that is removal of uterus, along with salpingo-oophorectomy. This is about entire case. Patient was discharged, and later on, Samira came to know that she lost her uterus and ovaries also, and she filed a complaint before police about this mishap or mischief committed by the Dr. Prabha for alleged negligence and unauthorized removal of reproductive organ. This is the allegation. Her allegation was there was a negligence while performing the surgery, the procedure, and the doctor removed unauthorizedly my uterus and reproductive organs also. And what compensation she asked, sought from the court. Further, she approached the consumer court, filing the complaint before the police, and then she approached National Consumer Commission, Delhi, and sought compensation for loss of reproductive organs, then consequential loss for opportunity to become a mother, then the diminished matrimonial prospects, yes, physical injury resulting loss of vital body organs, then irreversible permanent damage for pain, suffering, emotional stress, trauma, and so on. She demanded rupees 25 lakhs from the hospital or Dr. Prabha Manachanda, that is a respondent. The complainant alleged that doctor was negligent in treating her. The allegation, see the allegation, she was negligent in treating her. Radical surgery by which her uterus, ovaries and fallopian tubes were removed without her consent when she was under GA. Now tell me, I want to know from your end whether the Dr. Prabha did the surgery, whether it was correct decision. What is your opinion? Now we'll analyze dissect the judgment. This was the case. She was unmarried lady, 44 years, history of continuous bleeding, 8 to 9 days, and so on, some gynec problems. On examination, advised USG, doctor suggested laparoscopic study, diagnostic laparoscopy. Remember, diagnostic laparoscopy. But during laparoscopy, she was under a general anesthesia. Patient was under general anesthesia. They found some pathology, maybe endometriosis, chocolate cyst, or anything, and some tumor fibroid also, and proceeded for hysterectomy. There was no consent of patient, but consent of her mother, who was waiting outside. Now, whether this is a valid consent, I want to ask you. Why? Yes. Yes, they have not explained before the procedure. Okay. Yes. Yes. Okay. If doctor has done in the good faith, then also okay. Let us analyze the judgment. The defense before the National Commission was the laparoscopic. See, the laparoscopic examination revealed frozen pelvis. Considered extent of lesion was decided. Conservative surgery was not advisable, or conservative treatment was not advisable. Conservative treatment means this medication, danazol or any other thing, or conservative surgery, just do laparoscopy and close the this was not advisable. This was the defense from Dr. Prabha. And the nature of problem required hysterectomy for its cure. So for the cure of the patient, she performed hysterectomy. She further contended that consent given by the patient's mother for the hysterectomy should be considered as valid consent for performing hysterectomy and PSO. Now the question is, decision to remove uterus and ovaries was made on table by the surgeon, considering the best interest of the patient. So these are the three defenses doctor took. She told, in the best interest I have done this to avoid, because this was the best treatment to cure her complaints, and her mother gave the consent, it was a valid consent. And what court said now? The court observed the surgical notes were there, and the court observed that even the Supreme Court, the appeal was in the Supreme Court, because before that I will tell, the National Commission dismissed the complaint, and Samira challenged this dismissal before the Supreme Court, And Supreme Court's observed that. Supreme Court's observation is it confirms the surgical notes, surgical findings were no, there was no emergency. Because suppose during laparoscopy there was huge profuse bleeding or any emergency or anything, then definitely you have to go further. Like atonic uterus, you have to go for hysterectomy. There is no need of consent, also emergency, but it should be informed the relatives and other. Now there was no emergency or life-threatening situation developed during laparoscopy. Then secondly, the patient was neither minor nor mentally challenged. Why this word came? If the patient is minor and mentally challenged, then you can take the consent of their guardians. So in this case, patient was not minor or not mentally challenged or not under any influence or not incapacitated also. Patient was well to do. Then when the patient is competent adult, there is no question of someone else giving consent on her behalf. Now the question arises, she was under general anesthesia. So whether I should wait for her recovery. She was under GA, so I have to wait for 1 hour, then I have to take the consent. So I proceeded, their defense was. The appellant was only temporarily unconscious. The court observed that whatever it is, 1 hour, 2 hour, it was temporarily unconscious, undergoing only diagnostic procedure by the way of laparoscopy. Then court further said, the doctor ought to have waited till patient regained consciousness. See, this is very beautiful judgment. If you have not read once Justice Ravindran elaborately discussed. Justice Ravindran's judgments are very nice. He has fantastically discussed about the consent. Doctor ought to have waited till patient regained consciousness, then discussed the result of laparoscopic examination. There was ample time. It was not emergency. Okay, let the patient recover recover to the consciousness, discuss the result, and then taken the consent for removal of the uterus and ovaries. The time you can perform in the same setting or later decide. I have told in the last lecture also, it is the personal autonomy. Consent, what somebody should do with my body, what doctor should do with my body. Patient has absolute personal autonomy. Remember, you have no right to invade him without his consent. Okay. So in absence of emergency and as the matter still it was the stage of diagnosis. See, it was at the stage of diagnosis. The question of taking her mother's consent was a radical surgery did not arise. The very fact of such consent, there was no prior consent for hysterectomy by the patient. As you told just now, there was no prior consent for hysterectomy. If the doctor, Prabha, had explained, if we see something, if there is a danger to your life, if we feel your uterus to be removed, then definitely Prabha was saved. Now, what is the question here? Whether the correctness of decision to removal of surgery or failure to obtain the consent. The court came heavily on that, no doubt, your decision, the correctness of the decision was correct. You have done, the decision was correct, that will save the money of the patient, agony of the patient and other things. But now, whether there was a failure of the taking consent for removal of those organs, it is a vital issue in this because consent revolves on personal autonomy. As she was admitted only for diagnostic procedure, you told, you come, ultrasound was done. Come tomorrow, we'll do laparoscopic diagnostic procedure. Then you have no right to go further and chop her uterus or anything. Then she had given consent only for laparoscopy, and as her mother's consent for conducting hysterectomy had been obtained by misrepresentation. It is very important word, misrepresentation. I will show if you have gone through the judgment in the para 15, I think, the para 15 of the judgment, I will read that para. They misrepresented it. They have not disclosed the patient after surgery. Surgery, I think 10th May surgery took place. They have not disclosed that patient that we have removed your uterus. This is the first blunder. Accidentally or casually, the respondent number 2, there is somebody from the hospital, they told your uterus also removed during this procedure. Then she came to know on 15th. Surgery was done on 10th, but after discharge she came to know my uterus also removed with ovaries. So it was a misrepresentation. There was no valid consent for the radical surgery. So what court did now? The duty of court is to balance the things, because doctor has done in good faith. Court will consider, court gives highest regard to the doctor's duty also. But this failure, certainly that unmarried lady, she suffered, her uterus has gone, her psyche and other all things, sexual life and other everything became jeopardy. So definitely court was also conscious on the side of patient also. So considering the facts and circumstances, the court observed that because the Prabha Manachanda did not charge the patient, court considered that and became lenient to award the punishment and directed to pay the compensation of 25,000 for the unauthorized hysterectomy with BSO to the appellant. Yes, this is the case. Now I told about the misrepresentation. What misrepresentation? I'll read the para. Anybody had judgment? Anybody brought the judgment? Or open in your mobile also? The misrepresentation was, what they misrepresented to the patient's mother was that Lata, she came out and she told, your daughter is bleeding heavily, there is a profuse bleeding, and we have to take the decision for hysterectomy. That's why the mother got afraid and she signed the paper, consent form. Whatever best possible you can do. This was a misrepresentation. Second misrepresentation was they have not disclosed. After surgery also, Dr. Prabha Manachanda has not disclosed that during diagnostic laparoscopy, we have proceeded for hysterectomy also. This was second blunder. So the golden points here, what to remember. Law does not accept paternalism. Mother's consent, not valid. If it is a child, there is another case of Honorable Supreme Court, Nikhil super speciality case, or Martin D'Souza's case, Martin D'Souza. In that case, the child was there. Child suffered some injury, child suffered medical negligence, and the parents filed the complaint. The doctor challenged. Parents were not consumers. How the parents file the complaint? Parents are not consumers because they have not taken treatment. But court held that parents, the child was minor, so on behalf of minor, parents can file the complaint. So indirectly, the beneficiary are the parents, so they can file the complaint. The first priority always right of autonomy. I'm telling consent. If you have access to ethics, books of ethics, read the chapter consent. It is a personal right of autonomy. Every person, each and every person has a right. Even if you say, if you won't undergo this treatment, if you won't undergo this surgery, you will die. You are a doctor, you are convincing the patient, but patient will say, no, I don't want, let me die. You cannot force, you cannot touch the patient, or this is the thing, law has prescribed it. However, the broad consent might be diagnostic procedure, it can't be used for therapeutic purpose. In this instant case, it was the diagnostic consent procedure, can't be used for therapeutic. Then the prior informed consent, except in life-threatening or emergent situation. Now you will ask, if there is an emergency, in the gynec especially, if there is an emergency, or road traffic accident, or fracture, or anything, patient cardiac arrest, or anything, that time whether shall we wait for the consent from the patient? No. In the emergency, it is your duty to first treat the patient. The consent is given by the state. State means government. If there is no one is there, what you will do? Head injury patient has come and nobody is there, and somebody lifted the body and brought to your hospital. Now what is your duty? You are sitting in the emergency, the casualty, and whether you don't examine, it is your duty. If you won't examine, that is that failure of duty of care and you are liable. So examine the patient, record the findings, then no law will ask you why you have done this, why you have stitched the scalp or whatever it is. If anything goes wrong with you also, law will not punish the doctor in that case. In the emergency, it is a waived off consent. Consent is not valid if taken for illegal activities. Now you can say, this comes MTP, illegal activities, septic abortion. Patient will come, or the young girl will come, and this is illegal. You have to intimate, you have to put in the register name, whatever the formality as per MTP Act 2021. Then any illegal activities to conceal many the forensic issues. I request Dr. Manjunath to speak on this about illegal activities, consent and illegal activities. Take the help of non-interested parties when needed. What it means? Because there are some conflict of interest. Somebody is interested to harm the patient. So non-interested parties are necessary, because in this instant case, mother, she is a mother, okay, but if there is a husband, we don't know what is, she was unmarried, but brothers and sisters, in that case, some conflict of interest may arise, and if they say, okay, do the hysterectomy, the property issues, a lot of criminal issues, they erupt. Then video recording is also important. If you feel that trouble creators, patients are trouble creators, take video consent, it is better. Then the separate consent is needed when you do separate procedures. Remember, Now tell me, you are performing abdominal surgery and or Caesar operation. Will you take out appendix? I think most are surgery people here and appendix, it is a common notion. If you do laparotomy, take the appendix, take out the appendix. Yes, it is a common practice from my days also from 87. My friends and many, everybody is doing. Whether it is justified, whether it is unauthorized invasion or unauthorized removal of the organ. So if you are a practicing surgeon, don't remove the appendix. If you are eager to remove the appendix, then do the things. Tell the patient in advance. See, we are doing the whatever hysterectomy surgery and other. If we find appendix, any problem with the appendix, we will remove. Don't tell that we will remove the appendix because we are doing the laparotomy. Don't tell. If we find, if doctor, the operating surgeon feels there is any problem with the appendix, we want to remove. Give the consent. If you say if it is a normal appendix and you removed, then he is well within limit to file a complaint against you for unauthorized invasion or organ theft also. No doubt it is a vestigial organ and you can remove, but no, in any surgical book or in any text or in any research paper, it has given or stated that during any laparotomy you can do appendicectomy. Suppose you have removed, in good faith, you have removed the appendix, then make your surgical notes very perfect. Right, the appendix was angry looking. Right, the appendix was angry looking in the surgical notes. Now the question will not solve here. Now patients are also intelligent. You will send the hysterectomy specimen for pathology study, histopathological study. Send the appendix also. If you don't send the appendix, then the dilemma starts, why you are not sent? You have intentionally. Now the next rider is, if the pathologist gives the report, appendix is normal, then again you will be in the soup. See, it is a chain of event. Best way, you convince the patient, see appendix we will remove or it will create problem in future. If we feel some problem with appendix, we will remove. This is the thing. So any questions? Now this one slide I wanted to discuss. See, this is the misrepresentation. Can you read this? Some slide. When the appellant means the patient was under GA, respondent, the doctor rushed in the operation theatre, told the mother of out of the operation theatre, that Lata, told the appellant's mother that she had started bleeding profusely, gave an impression that the only way to save her life by performing extensive surgery. The appellant's aged mother was made to believe that there was life-threatening situation and her signature was taken on some paper. See, this was a blunder. Then what court observed? The respondent did not choose to wait till appellant regained consciousness. Respondents means doctor. Prabha Manachanda did not wait till the patient regained the consciousness. And the findings of laparoscopy test and take her consent for treatment. The appellant was kept in the dark about the radical surgery performed her. See, this is the next blunder they have done. She came to know on 14th when respondent's son casually informed her about the removal of reproach. Casually. Why just casually? See, the next highlighted when she asked, when the patient asked the doctor, Prabha, why you have removed? She politely asked why you have removed, why there should be profuse bleeding during the laparoscopic procedure. And you would have consulted some expert that time. That time what happened? Or take another opinion. The respondent means the doctor answered rudely due to her age, that due to her age conception was not possible, therefore the removal of her reproductive organs did not make any difference. So whether she has any right, your age will not permit, you will not get children now, reproductive organs, and removal will not make any difference, whether that doctor has a right to tell her. This is the crux. Because of the rudeness, because of misrepresentation. If the doctor politely told, if she politely told it was necessary, this happened, I think Samira would not have approached the Supreme Court or this thing. So we need good doctor-patient relationship, good communication, good explanation, and other things. Now, another is in the para 14, Supreme Court also discussed very nicely what is consent. Consent is, remember last time also I have shown one slide, brand. What is consent? Informed consent. Brand means, remember the brand word. B is benefits of the treatment. R is risks of the treatment. A is alternatives, if any, for your treatment or procedure. BRA, N is no treatment, whether there is a treatment or not, no treatment. And D is documentation. Supreme Court elaborated this in para number 14 that the doctor should disclose the nature and purpose of the proposed procedure or treatment, the expected benefits, outcome, and the likelihood of success. He has to discuss the risks of the treatment, the alternatives to the procedure, and supporting information. The effect of no treatment or procedure, including effect on prognosis and material risks also. And it also includes your instructions concerning what should be done if procedure turns out to be harmful or unsuccessful. So all are the ingredients of the informed consent. So go through this judgment. It is wonderful judgment. You will understand each and every point. So then para 15 also discussed the basic principles of consent. Basic principles of the consent. What is implied consent? The patient enters in your chamber. If the patient enters in your consulting chamber, it is an implied consent. He agrees, yes, let the doctor examine me. And you also agree, you have given the consent, doctor also gave the consent. Yes, I am ready to examine the patient. It is an implied consent. Then it has also discussed about the real consent, real valid consent. Patient should give real valid consent. In this case, if Prabha would have explained, see, we are performing laparoscopy, and during laparoscopy, if we find, suppose there is a tumor, ovarian tumor, or some other tumor from other organs, then we have to proceed for the further surgery. We don't know. You may need extended surgery. Then she will give, yes, you go ahead, anything you note. That is a valid informed consent. Then there are different types of consents. And also I want you to read para number 26, 27 and 28. Now this judgment discussed about in this 26, 27, 28 about the government doctors, private doctors, and how the private corporates are functioning. But any doctor, whether government, private, or NGO or trust, Supreme Court has not given relief about the consent. Consent is must. Supreme Court elaborated that government doctors and charitable hospitals, they are more burdened with the work, and there are chances of missing of the consent, but it is not excusable also. But another way, the private hospitals, they consents, they take consent for each and everything. In Delhi, where I was there in Delhi, and sometimes some occasions I visited the corporate hospitals. So there are number of Fortis, Medanta, Apollo, and a lot of Max. And once I have gone through one hospital's consent form, not consent booklet, it is a form, not form. Nobody will read, and just everybody will sign. On each page you have to sign. I was surprised, they have maintained the book. If I enter in the room, private rooms, I will put the blue color slipper. There are different color slippers. So such a way they have taken the consent, in depth they have taken the consent. Then I asked, why you have made this? Because to avoid or to do the defense or anything, because patient relatives, they visit the hospital, the ward, the hospital-borne infections. This is the area where litigations are more. So to avoid that, we take that consent. We provide our hospital chappal, our this thing, everything. It should not go out. So such a consent they take. But remember, for the procedure or any invasive procedure or to touch also, in this this judgment, Supreme Court also discussed in one para about, I think para number 41 or so, to touch the patient also. To touch the patient unintentionally or intentionally, it may amounts to battery. Battery is the legal word. It is creating harm or insulting or battering. So to touch the patient, you need the consent also. So with this, I think, any questions? Because my duty is to your next generation doctors, consultants, and I wish you should not come into legal tangle. Be careful. Now the world of the patients are more conscious, patient relatives are conscious, electronic media, AI, everything is there. Where you will be caught, how you will be caught, definitely you have to protect, you should be very vigilant in each and every aspect and each step. So I request Dr. Manjunath, anything about, if you want to say about the consent. Thank you. Any questions, please?
We are doing cesarean section, sir, but there will be bleeding. But patient in the GA, so to save the patient's life, we won't surgeon himself will go outside, talk to attenders, take consent, come and give to instructor. That's what the patient is on GA, bleeding heavily. Is that okay or?
No, patient is bleeding, and if you intimate, so you are, I don't know whether you have taken consent for laparoscopy or what.
Cesarean section.
Cesarean section, yes. Cesarean section, yes, you have to take the consent of the relative only, because that is not an offense, but they will take the allegations. Patient party will do the allegations. They will say they have told a lie and other thing, because your operative notes should reflect. In the operative notes, it should reflect patient is bleeding and so, or abrasio placenta, whatever you are finding the the delivery notes. No, that is important. Simply, if you say patient was bleeding, what? Whether you have cut the femoral artery, then the question will come. Femoral artery. There are instances the femoral artery was cut.
Internal iliac.
That internal iliac of the branch. This was the case. Then we applied res ipsa locator. Res ipsa locator means things speak on itself. No need to prove. The surgeon cut the internal iliac. There was profuse bleeding. Now, if you say profuse bleeding, take the consent. The allegation will come, why profuse bleeding? What is your explanation? You have to write. If the patient succumb, then the things start. Because many times this artery injury, they are concealed.
That is a procedure to prevent the bleeding, internal ligation.
Ligation is the procedure.
To prevent PPH,
Yes.
go ahead with the ligation. That case, still many times it may not be sufficient to.
No, in the emergency you have taken the consent, that is correct. But if it is a planned surgery, then no.
Emergency sometimes.
Emergency, there is no bar. You can take suppose there is nobody is there. Here mother is there, but some relative. You have to inform. But write in your notes, informed some XYZ, brother, sister, friend, whatever it is, about this happening, and took the consent.
The other problem is we take a surgery, we arrange only one point of blood, but no attendant is there to arrange the blood. All the time, that is a problem. You take for surgery, there is a need of blood, we get difficult to arrange one point of blood from the local blood bank. But no attendant is there to bring some more blood.
No, then try to tell them instead of one bottle, you tell 2 bottles.
When nobody is there, there is a problem. One or two will explain better.
No, if it is a planned surgery, then if it is a planned surgery,
Emergency they come.
emergency.
Emergency they come. One point somehow students and all get one point.
No, you see the document here. The documentation is very important. You have made the attempt to procure the blood. One unit you have procured from your blood bank.
Yes.
One unit, another extra unit you have requested, but nobody was there.
Yes.
You record that. We have the form is there. We have asked. There were no relatives. Even the blood bank has no stock. You can record this. See, whatever the procedure you have done, then what you did for the patient at that point of time. Any questions? But I request you should read this judgment. as a story, but you will gain much more before you enter in the practice. There is a Samira Kohli, then Montgomery judgment, whether you heard or not, I don't know. Montgomery judgment, Montgomery was the patient, she was a diabetic. Now the delivery, again the obstetric case, the duty of obstetrician was to inform. Obstetrician was aware she was a diabetic. Then diabetics are more prone for shoulder dystocia. She has not discussed this complication. You may have shoulder dystocia. Unfortunately, she delivered shoulder dystocia, and the Montgomery versus Larrax had, I think, the judgment in 2015, UK judgment. If you get through Google, you can download and read that judgment. So what you should disclose, it has given. It is evolution, Canterbury judgment. There are many judgments. Yes, sir, any questions?
I think, the attendees, they have asked a few questions. My concern was this: in what in case during the procedure only he before mentioned Madilla as was asked. Could we consider that as a sentinel event and go ahead with the procedure and then go ahead with the that is mandatory that we have to between the procedure it is same for the same case what you are saying, sir. And in case there was some bleeding which has happened, actually, our time only, how could have been handled? That is my point. If there is any such case comes and we are dealing with that, how is that we have to go ahead with that?
No, if the bleeding, see, bleeding, why the bleeding was there, that is the important question. Whether bleeding occurred spontaneous or by your mistake or the disease process itself. Now the question will arise whether she went into DIC or whatever it is. That now the question is, there was a bleeding. What you have done, what court will analyze, what you have done in this case. The bleeding was there, consent, forget about the consent. What the duty of care starts, whether you have sent blood for the coagulation profile immediately, tried to procure the blood, the coagulation factor or platelet or anything, whether you have tried, or there is any, whether there is any, sorry, whether there is any procedural fault, because allegation, the patient's allegation will start on that. Now, how to protect? First is documentation. You document. Now, here consent will fall pale here. I won't think consent will not come. It was an emergency. OT notes should be there. If you write in single line, patient was bleeding, it is not sufficient. Why there was bleeding? You have to explain in the court why there was bleeding. This is very vital. Then why there was bleeding and what you did that time? What was your duty at that time? If you say we have already ordered the blood in the morning, no blood was available, no excuse. It is your duty. We have immediately contacted the relatives, no relatives was there. Immediately blood was sent for the investigations. Despite all, the patient was bleeding and we have to do Caesar hysterectomy. Caesar hysterectomy we have done. So why you have not taken consent? The court will never ask, because to save the life of the patient. But unfortunately patient dies. Suppose we take here, you have not taken consent and patient dies. Now whether you are liable? No. Because you are in catch-22 situation, what to do? Devil and sea is here, what to do? I want to save the patient by any means. I have tried everything, ligation, this thing, this thing. Finally, I have to chop off the uterus. Despite that, she went into DIC and died. Now, where is the consent will come? Consent will not. Court is also conscious whether consent is necessary. But if it is a frozen abdomen or anything, malignancy, that time you have to ask the relatives or anything whether we proceed for further. Some are inoperable, no treatment. The malignancy case, entire abdomen is frozen. They want to see, but entire abdomen frozen, they won't do anything and close the abdomen. So no treatment. But suppose if he ventures further, this is wrong.
So at the end of this, the request is that we have the standard consents right now. I will be sharing a soft copy of the same thing for you to just look into it if anything could be amended.
No, no, I think many consent forms are revised here. I have revised, even though we will revise the many things, we have to do.
Review that from
Yes, yes, we will review because most of the cases are on consent and documentation. If you go court in the court, most of the things are on the consent only. The doctors they fail to take the consent.
Department is a procedure wise, we have made a consent of and consent because you can change the left to right, that way you can make made. And department is a procedure is we make the consent form something standard, procedure specific, procedure specific. Procedure if it is given to department, it will be very useful for the doctor also, hospital also, and patient. The consent form is lacking in many of the hospitals because there is no standard something which is public. They are published by some authorities, but the government authorized what the law expects. This is the way it is. That's what.
No, no, consent.
Government specific.
There is no as such because by improvement only consent, because there is a judgment, reprinted consent forms.
Because a person A takes full consent, but B takes definitely will change. Then there will be a problem.
The matter is pending before Supreme Court.
So this brand at the it has to be present across the
Brand is remember brand whether it is just I made the simple small short idu madine brand if you remember.
Perspective, if you provide a standard consent, you can modify it depending upon the patient.
Yes.
And that we need very wide each development so that
Because
review
review ಮಾಡೋಣಲ್ಲ we will review the consent form.
ನಾನ್ ಕನ್ಸೆಂಟ್ ತಗೊಳೋದು ನಾವು ಇನ್ನೊಬ್ರು ತಗೊಳೋದು ಡೆಫಿನೆಟ್ಲಿ ಚೇಂಜ್ ಇದೆ ಇರುತ್ತೆ ಎಲ್ಲನೂ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಹೋಗೋದು ಕಷ್ಟ ಆಗುತ್ತೆ ಪ್ರತಿ ಪೇಷಂಟ್ದು ಯೂನಿಟ್ನವ್ರು ಮಾಡ್ಕೋಬೇಕು ಸ್ಟ್ಯಾಂಡರ್ಡ್ಸ್
doctor has to ensure it is done by
ಪ್ರಿಂಟೆಡ್ ಇರೋಕ್ಕೆಲ್ಲ ಸರ್ ಶುಡ್ ರೈಟಿಂಗ್ ಅಂತ ಹೇಳ್ತಾರೆ
No, no, no. See, printed consent forms are valid, but it should deemed appears to be informed consent. Now, suppose if you have a consent form, one consent form is there. Whether you can use for all the operation theatres, one consent form, patient's name, age, sex, doctor's name, and below that you have printed everything. Doctor has explained me all the complications. Doctor explained me you may need blood, you may land in emergency, you may need ICU admission, and this thing, and sign.
that right now.
No, this is wrong.
Specific we have got specific content. That has to be revived again. That has to be revived again.
MRC OG, they have a concern. If you have any of your friends across borders in US, the sir you just mentioned about risk. There even 1% of genetic abnormality they will.
Yes, yes, they write.
Percentage of death also they write.
Yes, everything you.
That is their agreed, but how can we, how far it is applicable for our
cultural norms in India, what I have seen is if you have to explain to the patient even 1% of chances generally definitely to save yourself. But when you're explaining to the patient, you say these are the chances because the patient says it's normal, normal delivery after mostly ಆಗ್ಬೋದು ಬಟ್ ಇದೆಲ್ಲ ಚಾನ್ಸಸ್ ಇದೆ ನಾರ್ಮಲ್ಸ್ ಇದೆ ನೀವು ಹೇಳಬೇಕು ಅಲ್ಲಿ ಬರೀಬೇಕು ಸರ್ ಮಾಡಿಸೋ ಸರ್
ಇಲ್ಲ ಮಾಡೋಣ.
You want that, sir?
We'll do. It is the need of our, what I feel, consent and documentation I am observing. Yes.
Just protocols, the hospital inspection.
Okay.
Yes.
Madu.
Also prepare for that one.
Thank you very much. Thank you. Yes. Yes, yes.
Which the patient will understand us.
Yes, sir.
So majority is Kannada, but what we if the concept is full of English. So is that valid to take that, sir? Because at last the patient attenders might tell that we have not understood. They simply get the sign. Is that valid?
No, it is not valid. That's why. See.
Because sir, as we saw the case sheet, there is both Kannada and English consent for cesarean section. For gynecological elective cases or whatever diagnostic cases, there are no Kannada consent. We and PGs used to write the consent, which every procedure has been explained. Then the consent is
Now
changed.
for this, for this,
If anything happens, if the has this Kannada format anywhere else, cover, sir.
For
Then-
that, as per NDPH standards, so ಎರಡು both bilingual language ಅಲ್ಲಿ ಇರ್ತದೆ. ಒಂದು ಸ್ಟ್ಯಾಂಡರ್ಡ್
local language ಮತ್ತೆ English.
local language is Kannada. So any of the lines that is being printed, it will be in both the languages. So ಅದನ್ನ we are getting.
Now, I would like to suggest, so after so many such deliberations, what I would like to suggest, your question is valid. So, in the consent form, put 4 to 5 lines in the last para, before signature, blank lines, blank lines in your consent form. You are explaining the patient or patient relative, minor if it is a minor. Then take in his or her handwriting, in Kannada or whatever it is, Telugu, Kannada, whatever it is. Whatever is printed above is explained by the doctor in my language and I understood and I am ready and I consent for the above procedure and so and so. If this is, don't write yourself, I am telling. Take in writing from that fellow. Tomorrow, I won't think he will shirk away from his writing that I won't understood or anything because he wrote, he signed. Whatever he has written, he will reproduce there. So this will be the proper way, I think. Yes.
What if he is illiterate? He doesn't know how to write. Just knows.
No, okay. If he doesn't, he is illiterate. His friend, his near relative, take in writing. I so and so, father, brother. Huh?
Video consulting, audio video consulting.
Video consent, you take video consent, it will protect further. That fellow was sitting here, we explained. Huh? If he is illiterate, finally they may create many grounds. ನನ್ನ ಮೂಡೇ ಇರಲಿಲ್ಲ ಅಂತಾರೆ, ಹಿಂಗೂ ಬಂದಿದೆ. They were explaining, I was not in the mood. So this is, see, try to protect yourself. Take as much as, take in his handwriting. Suppose if he is unable to write, take his mother, father, relative, anybody, write, I so and so father of this person, understood, and I have explained this fellow about this surgery and other, and we consent for this surgery.
To be
consent we'll sit, otherwise you come, we'll sit one day
So
and
that the OT put 1, 2, 3, 4 process, they should pick up that consent form.
yes, yes, consent should be subject specific. Don't make generalized consent form.
Specific, the OBG1, OBG2 was put there. Take it.
ಹಾಗೆ ಮಾಡಿ because many times the things may go wrong in the court of law.
It's
Yes.
both English and Kannada, your local language.
Sir, one more thing is, I think one more such class on death certificate is needed again. Previously, it was discussed in previous government meeting. Many of the PGs, many of the SRs also, they are aware of how to write a death certificate appropriate. So that is also
Death certificate, I think there is one topic in our this ಈ lecture series ದಾಗ ಇದೆ. I think we'll take up that matter also.
in-house ಮಾಡಿ ಬೇಕಾದ್ರೆ.
I think we need help of forensic people. They are more well versed with the death certificate and other. How to write, time, ಇದು ಅದು ಭಾಳ MLC, non-MLC, ಇದು ಎಲ್ಲ there are legality because ಅದೇ ನಿಮ್ಮದು PG ರೆಸಿಡೆಂಟ್ ಅವ್ರಿಗೆ ಕರಿಬೇಕು, ಅವರು ಬಂದ್ರೆ ಐ ಥಿಂಕ್ ದೇ ನೀಡ್ ದ್ಯಾಟ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು, ಥ್ಯಾಂಕ್ ಯು.
The review of this thing will do ASAP, sir, as soon as possible.
ಬನ್ನಿ, ಯಾವಾಗ
I'll get my quality person also. She is handling the formulation of all the wordings ಎಲ್ಲ
ನಾನು ಅದೇ ನಾಳೆ ಇಲ್ಲಿ ಕಾನ್ಫರೆನ್ಸ್ದಾಗ ಸ್ಪೀಚ್ ಇದೆ.
sir.